I would note that we did, right after 9/11, imprison a lot of people who were, it turned out to it was unwarranted, and people who were put away and had no ability to contact a lawyer, no ability to tell their family where they were. So I would just, since the ranking member asked that question, I would remind us that every one of these circumstances is a little different. So I think the comparison here to what happened during World War II is a little bit more significant than Mr. Bradbury might suggest, and I see Ms. Benai nodding her head. I want to start by thanking Chairman Feinstein for her incredible leadership on this issue last December when the Senate was debating the defense authorization bill. There were very few senators who were as tenacious as Chairman Feinstein in pushing for better language to be included to prevent the indefinite military detention of American citizens, and I really want to applaud her efforts to get a better bill passed into law. I filed 2 amendments that would have stripped 2 of the detention provisions from the defense authorization. Unfortunately, I was not able to get votes on my amendments, and despite our best efforts, Congress ended up passing a bill that will radically alter how we investigate, arrest, and detain individuals suspected of terrorism, and this, in my mind, is a complete mistake. The idea that we could arrest and detain U.S. citizens and other persons living in the U.S. indefinitely without charge, without trial by jury, a jury of their peers, and without having to prove guilt beyond a reasonable doubt is, in my opinion, a denigration of the Bill of Rights. It is a denigration of what our founders created when they established a civilian, non-military justice system for trying and punishing people for crimes they commit on U.S. soil. And while I support Senator Feinstein's bill and agree our priority should be in making sure that American citizens are not arrested by the military in the U.S., I think it is a mistake for the military to be authorized to detain anyone here in the United States, regardless of whether they are a citizen or not. Ms. Benai, when Congress enacted the Posse Comitatus Act just after the Civil War in 1878, or 13 years after the end of the war, we did so because we wanted to make it clear that the military could not and should not enforce our laws within the borders of the United States. Do you think the detention provisions that passed last year undermine that core principle and potentially put us one step closer to permitting martial law in this country?
Yes, would you?
Thank you very much, Senator, for that question. I have a couple of responses. No, we have not imprisoned innocent citizens en masse, but I would like to suggest that we need not. Fortunately, we haven't, but due process guarantees apply to individuals, no matter who they are. And there's a serious concern about allowing detention of citizens and anyone in the United States without due process. The issue during World War II is really who decides is guilty of espionage and sabotage. During World War II, the military decided, and I'm very, very concerned about who will make that decision today. There's also been expressed some concern about early access to Miranda warnings, courts, counsel. I don't think that's something to fear. I think that's something that this Constitution guarantees. It's also been said that anyone detained will have a right to habeas corpus. That guarantee did not do much for Japanese Americans during World War II. Japanese Americans were interned during the spring of 1942. It wasn't until the December of 1944 that Mitsue Endo's habeas corpus petition was granted to release Japanese Americans from internment camp. Yes, I am concerned that at present, right now, we're going to have the military involved in detaining citizens and giving military unfettered discretion in deciding who should be detained and who should not be. And that's a tremendous concern to me. I think there's tremendous parallels between what happened during World War II and what we're facing today.
Thank you, Ms. Benai. I'll note that I'm running out of time. I think in light of the courtesy that I extended to the ranking member, that I be granted. Well, I'll just, that's very generous of you, considering you're leaving. Well, I'll just take a moment here, because I don't like going over. And I just want to address this. Mr. Bradbury, I just have to confess, I'm not a little disappointed to see that you were called to testify before us today. I think it's important to remind people watching this hearing that you are the author of several memos that authorize the use of enhanced interrogation techniques, or what I and a lot of other people call torture, during the Bush administration. One of your memos specifically authorized the use of waterboarding, cramped confinement, slapping, stress positions, nudity, and dietary manipulation, and a subsequent memo said you could combine some of those techniques together and it would not constitute torture. In addition to this history, a lengthy investigation by the Office of Professional Responsibility concluded that you had drafted these memos with the goal of allowing the CIA torture program to continue. So it's very difficult for me, frankly, to rely on your legal opinion today. If the Office of Professional Responsibility questions your objectivity and reasonableness, then I think we on the panel all should as well. Again, I realize I've gone well over my time, and I think that I thank the chair for allowing me to make this quick note for the record. And Madam Chair, I would also like to add the Department of Justice's official professional responsibilities report on Mr. Bradbury to the record.
So ordered, and I thank you, Senator.